the irregular meeting of the Cyber Forum, irregular in the sense that we are meeting on a Thursday rather than on a Wednesday. So for us, it is irregular. But to compensate, so to speak, for that, we have a wonderful keynote speaker, Professor Rebecca Wexler from Berkeley Law, to be followed by our very own Karni Shagal, Dr. Karni Shagal, who's now doing her postdoc at the law school in Ottawa. And I'm going to give just briefly, I'm just going to briefly frame the issue. So we are going to talk about cyber forensics in the sense that what we care about is evidence obtained from computers or networked computers and devices that contain computerized components therein. This issue is relevant, of course, for the criminal procedure, but as we know, not only. So we would find neighboring discussions on the issue of cyber forensics in civil lawsuits, because the issue may pertain to evidence that are part of a civil, contractual, property, negligence, I mean, tort-related lawsuits as well, and also in family law. In fact, in family law, we often do find issues of forensic evidence because this is a way to prove stuff that needs to be proven sometime during family disputes that go to courts or go to other arbitration fora. So the issue is not particularly confined to criminal law, but of course in criminal law it is very prevalent. One other thing to be, just as a way of a frame, or actually two very brief other things. One is the relationship between law and technology here is of course also a major theme, because technology advances fast and then the legal regime has to adapt, but in some ways, the legal regime sometimes foresee or attempts to foresee some technological developments. And then the question is, how do you look into the future and try to regulate with technological developments in mind? And the last point I want to say is, of course, as we just mentioned in our brief chit-chat prior to the official commencement of the talk, is the notion of a transnational dimension. Because what happens in one jurisdiction, necessarily because of the transnational jurisdiction of the cybernetic dimension, impacts the legal systems of other jurisdictions. With that in mind, I've said enough. With that in mind, it is my pleasure to invite Professor Wexler to address the forum. Please, the floor is yours.
Wonderful. Thank you. Thanks for that introduction. Thank you all for coming on a day that you don't usually gather. Really appreciate it. Thank you to Professor Rackman for inviting me, Haifa University Center for Cyber Law and Policy for hosting. So I'm Rebecca Wexler. I work on data and technology in the criminal justice system. I'm going to talk about digital forensics. The issues I'm going to talk about do relate to digital device forensics. The examples I'm going to talk about also concern digital software systems that are used to analyze more traditional forensics. So it could be digital software systems used to analyze DNA, gait analysis, face recognition, as well as systems that are used to extract data from a hard drive or a cell phone. When we think about technology in the criminal justice system, we often think about law enforcement investigations. Law enforcement's use of predictive policing, risk assessment instruments, digital forensic software. We often overlook criminal defense counsel's access to and use of these same technologies, either to scrutinize and contest the results of a law enforcement investigation or to use these systems in their own investigations for innocence. And my work as a scholar overall focuses on this criminal defense investigation aspect, defendants' access to data and technology. And now this is why I was asking in the beginning a little bit about the differences in how inquisitorial versus adversarial your investigative system is. criminal defense investigations matter in the US an extreme amount because in our adversarial criminal system, defense counsel is the only actor tasked with investigating evidence of innocence. And this differs from other places where you might have some obligation on government investigators to seek out evidence of innocence. I don't know whether you have that or not, but in the US, and US criminal procedure scholars are sometimes even surprised to hear this, government actors have zero constitutional, statutory, or ethical duty to affirmatively seek out evidence of innocence. Therefore, legal barriers that suppress defense counsel's own independent subpoena power or investigative power mean selectively suppressing evidence of innocence. My talk today is going to present 3 different examples of legal barriers that US criminal defendants currently face in accessing digital forensic software systems. Again, either to scrutinize the government's case or to build their own. The 3 barriers are: first, trade secret laws; second, data privacy laws; and third, foreign data privacy laws combined with cross-border data flow treaties. So diving into the first, trade secrets. In 2015, a homicide defendant in California was denied information about a forensic software program that had been used to analyze key evidence against him because the company that builds and sells that system to the government said the information was a trade secret. The developer told the court that even disclosing the information to defense counsel, attorney's eyes only, under a protective order, could, quote, cause irreparable harm to his company by letting competitors copy him and, quote, put him out of business. And the court agreed. In 2015, it became what I think is the first appeals court in the US nation's history to apply and express an explicit trade secret evidentiary privilege in a criminal proceeding. The case is US versus Chubbs, or People versus Chubbs, and it's currently being cited across the country to justify withholding trade secret evidence from the accused. Now, you all know that the criminal justice system as a whole is becoming automated, and that process is causing conflicts between defendants' access to evidence and third-party intellectual property rights. So that example that I opened with is an example of trade secret evidence of guilt that's being introduced at trial, or trade secrets in a software system to analyze guilt used at trial. But trade secrets are also hindering defense challenges to other types of police investigatory technologies. So as another example, consider ShotSpotter. This is an audio surveillance system. It's supposed to send it's made up of audio sensors. They're placed throughout a neighborhood, and they're supposed to trigger on the sound of ambient gunshots and send these gunshot alerts to police. A defendant tried to subpoena information about how the sensors distinguish gunshots from the surrounding auditory environment on the theory that this system might violate state wiretapping laws by constantly recording conversations at normal speech volume. And the company quashed that subpoena again on trade secret grounds. So this issue occurs with investigative or forensic software systems that police now use to match suspects to crime scene evidence, from face recognition systems to fingerprint matching, gait analysis, iris scans, digital extractions. For forensic device extraction systems, companies are refusing to even sell the system to defense counsel. So Graykey, Celebrite, these companies only sell to law enforcement. You can't use it, you can't buy it, you can't test it if you're anyone other than law enforcement. So on the one hand, trade secret claims are impeding defense advocacy at all stages of criminal proceedings. And on the other hand, developers argue that they need this privilege for their trade secrets because, in their view, protective orders aren't reliable enough. People violate them. And even if that's unlikely to happen in any particular case, if developers are routinely required to disclose trade secrets in criminal proceedings, even under protective orders, then those cumulative risks of leaks will, in their view, become substantial. Now, courts are worried, for their part, that without the privilege, developers might decline to act as expert witnesses for the state, impeding government investigations. And the strongest version of that latter argument, the one that keeps me personally up at night, since, spoiler alert, I'm arguing against this trade secret protection. So the one that keeps me up at night is that some of the best new criminal justice technologies may come from developers who sell in a variety of markets. And they might choose to refuse to sell their tools to criminal justice customers if doing so means risking the security of trade secrets that they rely on in other, perhaps more profitable markets. So how do we resolve these conflicts? Today, the common view among legislatures, courts, and scholars alike is that some form of trade secret evidentiary privilege does and should exist, at least in civil proceedings. 2/3 of the states in the US have codified a privilege. Courts in most other jurisdictions recognize a common law variation. And there's a growing trend of courts extending that privilege wholesale without modification for due process concerns from civil into criminal proceedings. One leading evidence scholar said, even in criminal cases, companies have a, quote, a perfect right to assert the evidentiary privilege for their trade secrets. I challenge this view in favor of the trade secrets privilege by arguing that none should exist in criminal proceedings. So the developer's entitlement should be to a protective order, maybe a sealing order from public disclosure. An attorney's eyes protective order, we can debate what the terms of that should be, but it shouldn't entitle you to entirely withhold evidence from the defense that a judge has deemed relevant and material. And of course, I should have given this background before, but defense subpoenas are already quite burdensome. So what we're talking about here are subpoenas that a judge has reviewed in advance that have met a burdensome showing that they seek relevant, admissible evidence that they've identified with specificity. So my position is once you've met that burdensome standard, that should be enough to get the evidence, and developers should be able to protect their trade secrets to the full extent reasonable through protective orders or attorney's eyes only limitations. So why do I want to limit this? Now, given the rules and realities of criminal procedure, I think that privileging trade secrets in criminal cases is both particularly harmful and also unnecessary. It's harmful because in civil cases, comparatively, you're more likely to have evenly matched adversaries who are going to know how to use intellectual property to challenge whether a trade secret even exists. It's IP 101 for law students in the class. Is there even any IP here to protect? Criminal defense counsels don't have that experience generally with IP, sophisticated IP litigation. And so they're more likely to fall in the face of overbroad or abusive claims to a trade secret evidentiary privilege. And at least in the US, our state criminal courts, which are the courts that process most of the cases that have led to US mass incarceration, for instance, are bifurcated. So judges also are exclusively looking at criminal cases and aren't as used to the types of overclaiming or challenges in trade secret assertions. Another reason there's a greater risk of abusive and harassing, or I'm sorry, just abusive and overbroad assertions of the trade secret privilege in criminal cases is because there's not as much of a reason for it. In civil cases, you worry that if you disclose your trade secret to your adversary, they might actually be a business competitor. So they have an incentive to turn around and leak it, use it, destroy it, challenge it, whatever that would be. In criminal cases, you're not litigating against a business adversary. Due process is not a business competition. Compared to substantive trade secret law, I argue that the privilege overprotects intellectual property. And that's because, and I'd be curious to hear about IP in Israel, but in the US, it's very difficult, and in some jurisdictions not allowed, to get an injunction against the use of a trade secret when there is no existing threat of misappropriation. And this is what we are seeing in criminal defense investigations. Defense counsel isn't threatening to misappropriate, and yes, there's an injunction preventing their use of the information. So a quick update on, finally, I have a final argument about this as well. By the way, these are all in a Stanford Law Review article that I published called Life, Liberty, and Trade Secrets, Intellectual Property in the Criminal Justice System. A final argument in that paper is that the privilege in criminal cases doesn't serve the interests of either, or the purpose of either trade secret law or of privilege law. Now, I wanted to show you here just a couple of developments. Since I started working on this issue, I've been coordinating with Congressman Takano's office, a US representative, US House representative, who introduced this bill based in large part on the work that I did and also the work of others, to prohibit the use of trade secrets to prevent defense access to evidence. So where we're at right now, this was introduced in 2019. There's an idea that it might be introduced again in the next Congress. And it has this amendment to the federal rules, which are intended to say that trade secrets aren't going to abrogate defendants' otherwise valid rights. The other thing that's happening is another bill that's currently pending that, if I'm going to be completely honest, I think is much more likely to pass. And this bill is intended to provide a lot of resources to law enforcement in the US for support for digital forensics work, establish this Center for Excellence for Digital Forensics. And here, I was just earlier today earlier this week, interacting with somebody on the House Judiciary Committee who's trying to modify this portion of the bill a little bit to make it slightly more equitable for defendants. So this is a guide that's going to be given to law enforcement around what types of issues they should be worried about during the procurement stage for new technologies. And I'm hoping that they will add to this that the guidance should include conditions for procurement that would compel vendors to comply with court-ordered subpoenas and standard due process requirements in courts. I'm not advocating that law enforcement should have to exclusively rely on open source or public technologies. I am advocating that law enforcement, who is the primary market here and has extraordinary power at the procurement stage, if they don't wish to themselves gain possession of the information that might be subject to a trade secret claim because they don't want their own officers to be drained by having to go up on the stand and testify all the time, make the vendors agree to comply with court-ordered subpoenas. The second barrier that I'm going to talk about today for criminal defense investigations in digital forensics are data privacy laws. I'm going to start this second barrier by telling you a story about GitHub and the death penalty. A Texas death penalty inmate right now, as we speak, is trying to access source code in a forensic DNA software program used to convict him. The judge in that case found the code to be material and necessary for the administration of justice. And we can have an expert debate about how useful source code review is or isn't. This judge found it to be material and necessary for the administrative justice and ordered the company that developed it to disclose the source code under a strict protective order designed to safeguard the company's trade secrets. So exactly what I'm proposing in the trade secret case, order it disclosed under a protective order. In this case, the company, which is located in New Zealand and beyond the court's jurisdiction, refused to comply. So that company was willing to sell its software program for use in Texas courts, but not willing to let its product be subject to adversarial scrutiny by those courts. And when the death row inmate tried to get access to the same code stored in a repository with GitHub, a US company, GitHub argued that a key data privacy law for the internet called the Stored Communications Act categorically immunizes it from defense subpoenas and refused to comply. In this case, and many more like it, technology companies have argued that the SCA, the Stored Communications Act, entitles them not to comply with criminal defendant subpoenas for a non-party's communications contents. And source code, in their view, counts as communications contents. For over a decade, every appellate court in the US to have considered this issue nationwide, state and federal, has agreed that the Stored Communications Act categorically blocks defense subpoenas for this type of evidence, even evidence that could exonerate the wrongfully accused. By the way, the act has an express exception for law enforcement investigators. So companies are willing to give this information to the prosecution, but not to the defense. Now you say, well, why can't the court order the prosecutor to get it on behalf of the defense? And here we have a balance of powers problem. So courts are unwilling to do that or wary of doing that. And also because the Fourth Amendment in the US may require, likely requires law enforcement to obtain a warrant in order to get access to this type of evidence. And prosecutors have said they can't comply with their oath requirements to swear out probable cause when they're seeking evidence of innocence rather than evidence of guilt. So defendants are being blocked by this law and blocked on those other two routes. I argue in a forthcoming article in the Harvard Law Review called Privacy as Privilege that all of these cases, all of US federal and state appellate case law on this issue are wrong as a matter of binding Supreme Court doctrine and just policy. So I begin that article with a puzzle about the telegraph and the internet. It turns out that telegraph and the internet have many similar characteristics. In both of these communications networks, users have to send the contents of their messages through an intermediary service provider. And in both, the intermediary service provider often retains a copy of those contents. It's actually different than telephone companies, which are maybe the more likely analogy if you were just gonna zoom backwards from the internet, but telephone companies don't normally retain contents. Telegraph companies did, not for the data-driven business interests of today's tech companies, but because they wanted to protect themselves from liability for mistransmission. So you have this similar privacy concerns that come up. What if this service provider leaks my information, publishes it to the press without my authorization? And in response to that risk, legislators in both eras, the 19th century, the 20th, 21st century, have enacted privacy statutes to limit service provider disclosures. Now, many of those privacy statutes in the telegraph era lacked an express exception for compliance with court-ordered subpoenas, just like the Stored Communications Act does today. But strangely, courts in the 19th century were completely unconcerned by this statutory silence. They ordered telegraph companies to comply, to disclose contents and comply with these subpoenas anyway, despite the lack of an express exception. So why is it that telegraph courts came out that way and internet courts come out the other way? And I argue that the answer is that the 19th century courts understood something that 21st century courts have overlooked, which is that when you construe a statute to block valid compulsory legal process, you create an evidentiary privilege. And privileges have a different logic and a different set of statutory construction canons than other statutes because privileges impede the truth-seeking process of the courts. As a result, the US Supreme Court has said we must construe privileges narrowly. You must not construe a statute to block compulsory process and suppress evidence unless the statute requires that result. Okay, so what today's courts have been doing instead is applying the canon of construction known as expressio unius. And this is a canon of construction that says, effectively, when Congress makes a list of exceptions in a statute, we should presume Congress intended to exclude those not mentioned. The rationale being, Congress knows how to write these exceptions. It didn't write the one you want, in my case, for defense subpoenas, and therefore it must have intended to omit it. But if instead we understand this construction of the statute as an evidentiary privilege, it triggers an alternate statutory construction canon called the narrow construction rule. And that's effectively a clear statement rule that says the same logic, but flipped. Congress knows how to write evidentiary privileges. It does so in many statutes where it says expressly, this information shall be immune from compulsory process, this information shall not be subject to subpoena power, and it didn't write one here. So therefore we should presume it didn't intend to abrogate compulsory process. I argue that correcting the erroneous case law on this issue, and by the way, I'm actually litigating it as well. So we just filed a petition for review in the California State Supreme Court, and hopefully they'll get that and be able to fix this. But correcting the erroneous case law on this issue would increase accuracy and fairness in criminal proceedings with minimal harm to privacy, minimal risks of abuse, because effectively, it would mean that courts would get access to relevant evidence where there's no legitimate privacy interests. Situations like the one I mentioned with the trade secret barrier, other situations where trying to get the access from an alternate source might risk somebody's safety because it's a dangerous individual, or they might destroy or tamper with evidence. Those are situations where the current law blocks access to evidence without any privacy interest being protected at all. And this correction would fix it. I'm realizing 35 to 40 minutes goes by really fast. So I'll just put a pin in that.
No, it's fine, it's fine. No, go ahead.
Oh, really? Okay, yeah. All right. Because I have a timer on. I always think that I shouldn't go over, but okay, fine. Good. So it turns out that this asymmetry and this problem in the Stored Communications Act is actually a pattern throughout information privacy statutes in the US. So I'd be curious if it might be an issue in your domestic privacy statutes as well, where privacy laws almost always contain express exceptions for law enforcement investigations. And multiple people have documented law enforcement's powerful political influence and lobbying power to let legislatures know that they should, that they need to allow lawmakers to continue accessing sensitive information. And the criminal defense bar doesn't have parallel lobbying power. And so there's a predictable pattern where these statutes are going to advantage law enforcement investigations over criminal defense investigations. I address that broader trend in another forthcoming article in the UCLA Law Review called Privacy Asymmetries. And recall again, in the US, there's zero obligation for law enforcement to investigate evidence of innocence. So these asymmetries skew the system towards evidence of guilt. Beyond the doctrinal argument that I just gave you about privilege law, I also recommend that legislators who are enacting new privacy laws try to avoid accidentally or unintentionally proliferating these asymmetries by adding default symmetrical savings provisions to the end of each statute. And those savings provisions could say something like, nothing in this act shall be construed to prohibit a good faith response to otherwise valid warrants, subpoenas, or court orders. And what that would do is it would maintain the status quo investigative powers of both parties without giving either one more or giving either one less. Okay. The third barrier to defense investigations into digital evidence that I want to talk about today has to do with transnational cross-border data flows. Back to the story about GitHub and the death penalty. Recall that this inmate on death row got a court-ordered subpoena for the source code that the company in New Zealand refused to comply with. So we have a Texas court trying to order a company in New Zealand to comply with a subpoena. It turns out that police or prosecutors who were seeking the same information from the same company in New Zealand could have compelled that disclosure by using an MLAT, or Mutual Legal Assistance Treaty. But beginning in the Reagan administration, the US government began negotiating a series of these MLATs to facilitate law enforcement cooperation across borders. And beginning in the Reagan administration, these MLATs again expressly bar criminal defense investigators from using the procedures that they create. The first 3 US MLATs were symmetrical, Switzerland and 2 other companies, I can't remember, but the remainder have all been asymmetrical. Despite repeated criticism in the US Senate and the US courts, asymmetrical MLATs that enable law enforcement but not defense investigators to compel cross-border data disclosures have proliferated. And this morning, I checked the US-Israel MLAT, and indeed it is also asymmetrical. It states, quote, "The provisions of this treaty shall not give rise to any right that doesn't otherwise exist on the part of any private person to obtain, suppress, or exclude any evidence." And at least in the US, we treat even public defense counsel who are employees paid with taxpayer money, government employees, we treat them as private persons for purposes of construing these treaties and to exclude them from those processes. Now, the rise of the global data economy makes this MLAT asymmetry worse for at least 2 reasons. The first reason is that, as Professor Reichman was saying at the start, more relevant evidence in criminal cases is now digital and can now be located abroad. And we're not just talking about global criminal cases like terrorism or trafficking and global corporate crime, although those are also at issue here. We're also talking about common domestic criminal cases like burglary, even when all the alleged criminal conduct took place within the borders of the US. So the Texas example is an example like that, or you imagine somebody has a conspiracy maybe and their co-conspirators are located abroad, or perhaps they just have an email account with a foreign service provider. And so the first thing that makes these asymmetries worse is that there's more evidence at issue cross borders in more cases. And the second thing that makes this asymmetry worse is that other countries who, like the US legislature, are concerned about erosions of privacy and sovereignty interest are enacting data privacy protection and localization laws that risk blocking defense investigators' existing routes to compel cross-border data disclosures. So forget that they don't even have access to MLATs. These new data privacy protection and localization laws will block whatever access they did have, which is an extraordinarily slow judicial comity process called letters rogatory. I believe in Israel, I checked, you have these privacy protection regulations. Maybe those are the ones that would be most at issue here, becoming effective in 2018, but I'll be curious to hear from you what regulations you think may be at stake. So law enforcement in the US has 2 buffers against the erosion of its investigative power by new foreign data privacy laws. And defense investigators lack both of these buffers. The first is that law enforcement has exclusive access to MLAT procedures. And in 2018, Congress passed the Cloud Act, which empowers the government to negotiate a new series of cloud agreements with other countries that are designed to surpass MLATs in efficiency and expedite cross-border data disclosures. The first of these agreements between the US and the UK provides, again, for law enforcement, but not defense access. And there's every reason to think that the remainder will as well. In a forthcoming symposium essay that I have called The Cloud Act and the Accused, I propose a new interpretation of the Cloud Act that can help fix this problem. So a second prong of the Cloud Act, the first prong is we're going to negotiate a bunch of new, more efficient MLATs. The second prong of the Cloud Act asserts that US companies must comply with US court orders to disclose data, even if those companies store the data on foreign servers. And this is the big one, even if disclosing it would violate foreign laws. My legal interpretation of the Stored Communications Act, the one I just told you about in privacy as privilege, would actually permit US defense investigators to subpoena US companies for communications content stored abroad. So it would extend the government's new disclosure powers from law enforcement to include criminal defense investigators. So reading the Cloud Act alongside my interpretation of the Stored Communications Act would mean that defense investigators would get parity, some level of parity in cross-border data disclosures. Now, Professor Reichman started by saying that these issues aren't limited to criminal cases. And so for those of you in the audience who are interested in other issues, of course, that's correct. I will say many of the interpretations that I'm proposing would actually affect civil litigants as much as they would affect criminal defense counsel. And I'm just flagging that. You'll notice that each of the three barriers that I discussed today, trade secret laws, US data privacy laws, and foreign data privacy laws, each of these barriers are legal barriers that defense counsel faces to either scrutinize and contest digital forensic technologies or use them in the service of seeking innocence. Of course, there can also be technical barriers. So again, experts fight about source code. It can be complex to analyze. We know machine learning systems can be opaque, so transparency, or they're not explainable. What does transparency give us? Data can be burdensome, resource intensive to analyze, but lawyers are responsible for the legal barriers, and we can fix them. A number of scholars working in the law and political economy movement you might have heard about have called attention to something that they named the 20th century synthesis. And this is a notion that private economic laws that govern markets are somehow distinct from public laws that govern democratic functions. And that notion can blind us to the need and opportunity that new data-driven technologies pose for law and democracy. So one overarching trend that's happening with digital forensic technologies is that as the criminal legal system becomes more automated, it also becomes more privatized. And as a result, private economic laws, including IP, data privacy, risk undermining the public adversarial truth-seeking process of the courts. The law and political economy scholarly movement challenges us not merely to respond to private power with democratic regulation, but to acknowledge that the data economy doesn't simply leave law behind. It's aided and advanced by new legal orders that can often be shaped in the image of private power. And we as lawyers and as legal scholars are responsible for those legal orders. Thank you so much. I'm really excited to have a conversation with you about all of these issues.
Thank you so much, Rebecca, for a fascinating tour de force. It was amazing to see how you tie those three challenges together and make it so relevant also for us here in Israel. And without further ado, let's hear now from Carney. Carney, now the floor is yours.
Thank you very much. Thank you for the talk. I must admit, Rebecca, that I spied on you before the forum today, only on open data, of course. And I saw that you received several Best Papers awards, so I was really looking forward to reading your papers, and I'm very glad I did because they were super interesting as well as your talk. So I think most of my comments will actually focus on things that you have mentioned in them, but were very interesting, and I would like to ask you to elaborate on them in the forum. My comments will focus on your second point that has to do with the privacy laws. I think it's really interesting because usually in general in our cyber forum as well, when we talk about privacy, we talk about the big tech companies who infringe on privacy and as the right to be protected. And today the different angle is that these companies are actually using privacy in order to, for their own interest. And it's been using to hurt other human rights. So the different aspect is very interesting and fresh. And I wanted to first, in general, I think I wanted to maybe I know you addressed it in the paper, the Harvard Law Review, but to ask you to elaborate more on being the devil's advocate on the side of the privacy. So you made the very interesting analogy to the telegraph and showed why courts were then in the 19th century right, where they did not interpret the telegraph statutes as allowing privileges, whereas today they do. But I wanted to ask you to still, linger on the difference between telegraph and the media platforms we have today, because I think that first the likelihood of infringing upon privacy is bigger today. Back in the 19th century, if the telegraph companies were forced to reveal evidence about what someone wrote, what A wrote to B using the telegraph, it probably get no publicity, no one would hear about it. So it would be revealed maybe to the defense attorney, but that's it. And today, of course, depending on the case and the media and the PR, but today the likelihood and the impact on privacy might be much greater. If it's leaked or whatever, it becomes common knowledge. And not only is the likelihood bigger, but also, and you refer to it, but I would like to ask you to elaborate on it more. I think that the potential damage is bigger because back in the days, I don't know if anyone had any special interest in having people use the telegraph. I'm not sure. But you can say good things and bad things about the technology companies and the platforms that they offer, but obviously there are many advantages in that people can use them to share opinions and shape public discussions. And you referred to it, but the fact that they know that content may leak might discourage them from participating in this societal debates and sharing content as freely as they would have. That's one point where I think, I know your analysis is very, very legal. You also referred to the policy considerations, but I wanted to ask you to elaborate on that. And lastly, focusing again on the privacy issues, you offered that even if courts construct that there is privilege, it would not be an absolute privilege, but rather a qualified one. So that there is some sort of balance between the, of course, very important interests of the defense, the defendant, and still the infringement upon privacy. But I wanted to hear more about this balance. Do you think it should be decided on a case-per-case basis? For instance, I don't know if you make any differentiation if the information that's being asked is the data about locations and things like that, or the content itself of the messages or conversation, because obviously the potential for harm is usually greater in the latter one. also, you mentioned it now that it could have impacts on both the civil and criminal proceedings, but do you think that the balance should be different? I mean, obviously a death row defendant, his interests are probably more important than a litigant in a civil case. And if so, how do you think it should be shaped? And again, even in within the criminal proceeding itself, do you think it matters the type of crime he's I mean, the type of crime he's accused of, or the type of punishment expected. So if you could elaborate more on the rationales for, I mean, the other side's rationales for defending more on privacy, even in those circumstances, and the exact balance that you would propose if the privilege is qualified.
Well, thank you so much for those really deep, detailed, and insightful questions. And I am excited to hear about your work. So I'm going to try to not drone on for another 35 minutes and want more of an exchange, because these are so many wonderful questions to ask. So maybe in a more discussion-oriented way, but I could start out to say, first of all, yes, I think you're right that the scale of privacy threat from unauthorized disclosures in a digital world is greater than the scale of privacy threat from an unauthorized disclosure of a telegraph. And I don't think that as a policy matter, the internet has to be strictly analogous to the telegraph in order to justify my legal argument. I have, over time, had different reactions to including historical arguments in legal scholarship. But for me, I found this the first mention of this alternate statutory interpretation by reading these telegraph laws. And I just thought, wow, that makes sense, even if the technologies aren't strictly analogous. So I'm not requiring a policy analogy there. I make some of it, but it's not essential. But I am still saying that legal analysis should apply in today. So I agree with you overall that the scale of privacy harm could be greater in a digital world. But let me drill down a little bit and elaborate on why I think that eliminating the data privacy protection from defense subpoenas is actually not much of a threat to privacy at all. And that's because there are really three groups of people who are implicated by these defense subpoenas. Group A has no privacy interest at all. That's the group that I mentioned in the talk. They right now are able to withhold evidence from the courts because they're a dangerous person, because they flee, because they are unreliable. So you can't subpoena them for information. And therefore, if you can't subpoena the service provider, you can't get it at all. And of course, since they have no privacy interest, allowing us to subpoena the service provider is not going to eliminate their privacy. Then you have a group of people who do have a privacy interest, a legitimate privacy interest in contents. And I think you're right to say, well, contents can be more privacy invasive than non-content information, which is freely available to defense counsel under US law. So that's a little bit just of a notice of how much of a privacy concern we really should have. Non-content information subpoenaed all the time. And of course, I think as Carney is hinting at, there's a debate at this point, partly due to scale, about whether non-content and the content division really does track privacy invasiveness, or whether non-content information, at least collected in bulk, could be as or more privacy invasive than the particular content of a communication. But in any event, if we just concede that some people have a privacy interest and we want to protect that privacy interest, then I say, look, allowing defense counsel to subpoena a tech company maintains the same level of privacy protection so long as that individual receives notice of the subpoena. Because anybody who has notice of a subpoena has standing to move to quash. And they can move to quash in court and assert their privacy interest, whether the subpoena goes to them or goes to the service provider. So where we have a legitimate privacy interest, we maintain it. I'll say as well then the question is, well, how broad is the scope of this legitimate privacy interest? If we're talking about things that in the rest of the world, the non-digital world, we've already agreed are sufficiently private to be excluded from the courts. You know, we're not talking about normal confidentiality protections here, or normal privacy protections and what can a business do with your sensitive information. We're talking about suppressing evidence from the judiciary's truth-seeking process. And generally, the kinds of information that we've agreed as a society to suppress are extremely narrow. And we call them things like privileges. We call them the attorney-client privilege, the spousal communication privilege. These are the types of information sufficiently private to be categorically immunized. And those categorical barriers will still exist. So you don't destroy the attorney-client privilege by using reasonable encrypted communications on the cloud. Therefore, if you subpoena a cloud service provider for those communications, you still have the privilege and you can still assert it. And in terms of, well, what if you don't have a privilege? Then our standard baseline privacy protections in criminal procedure are balancing protections. So Carney asked extremely insightful question. Well, do you want this to resolve on a case-by-case basis? And I would say, other than things like attorney-client and spousal, yeah, I do. And by the way, that's what we do with non-digital private information all the time. Resolve it on a case-by-case basis. You have a privacy interest asserted in the court. If it's an unduly burdensome subpoena, then we'll quash it. So all of those things still are there. And then there's actually a third category, which are people we don't know whether they have a privacy interest or not because they're unavailable. And I would say those are people who are abroad. We can't contact them. Unfortunately, sometimes people who are incarcerated, we can't contact. We don't know their privacy interest. And so, or we have a more difficult time contacting those people because it's an unknown privacy interest. I don't think we should prioritize their unknown interest over the truth-seeking interest of the courts. So I think that got to a lot, and I want to go back to you to tell me if I haven't addressed something. But before I do, I just want to flag another case that I didn't talk about, which I think does clearly draw this connection between the criminal procedure rules and civil litigants and family law, which also Professor Reichman brought up in the beginning. There's another case I've written about in which an innocent man in New York City was arrested and jailed when a complaining witness showed police text messages and a voicemail recording that she said he had sent to her in violation of a family court protective order. So family court dispute, protective order, don't contact this person. Then this person shows up to police with evidence of text messages and voicemail contacts from the individual. He's arrested, he's jailed pre-trial. Rather than pleading guilty pre-trial, which we know a lot of people do when they're incarcerated pre-trial, there's a pressure, more people plead when they're incarcerated pre-trial than if they're out on their own recognizance pre-trial, because you're incarcerated pre-trial, you might lose your housing, you can't see your kids, you might lose your job, lots of pressures there. But he chose not to, he pled innocent, and his counsel believed him that these messages were faked. And randomly, because he had no idea how they could have been faked, exactly, randomly chose to subpoena the first spoofing company service that he could think of, a primary spoofing company service called SpoofCard. Now, SpoofCard's a way of disguising, spoofing is a strategy for disguising the source of your phone number, like changing the caller ID information so that you can send messages that appear to come from somebody else's phone number. And lots of people, I hear from family court judges, lots of people are claiming that messages that they did really send were spoofed. But in this case, defense counsel proved that that had happened. He turned out to kind of win the lottery. SpoofCard had records from the complaining witness and revealed them and showed she was a paid subscriber and she had used that service to spoof and falsify those messages in order to wrongfully accuse this person and have him incarcerated. And if it hadn't been for defendants' independent investigative power, that exonerating evidence would never be revealed. It's not evidence that the law enforcement had sought out. So I don't know, that just came to me when you're talking about the family law. But tell me, can you tell me a little bit about your work on these issues?
So I'll tell a little bit. It's very the initial stages. So we're trying to examine the admissibility of AI forensic evidence. And the tension here is that you might know that the algorithm for gait analysis or DNA recognition, you might assume that it's better than other more orthodox methods, but there's the related problem that I think has a lot to do with your topic, is that even if you would use that and you would know that in general it's better, there's the problem of transparency and explainability. I don't know if it's something that you want to talk about or address. I mean, this is a major issue, not only in evidence law, I think, but it deviates from the topic.
Well, no, I mean, I'm very curious. I'm happy to follow whatever your normal standard is. I'm happy to follow to go into more of an exchange, or to keep talking about my own stuff. I could blab on and on and on and bore everybody forever on the own stuff. That's all I'm saying. But in terms of that, I mean, it is the issues of the transparency and accountability on admissibility of these forensic algorithms. I'll just flag that the Takano bill that I mentioned that I've been working on, Congressman Takano also has gotten the U.S. Government Accountability Office to issue a two-part report on federal law enforcement's use of forensic algorithms to match suspects to crime scene evidence, including gait, face matching, DNA. And the first part was issued last spring that just documented, well, here are the algorithms that US law enforcement is using. And the second part's forthcoming. So just to flag for you, it might be interesting for your work. That second report is going to be issued sometime in the spring, and it's supposed to address some of the policy concerns around, this transparency and explainability and accountability issues.
And
so
also,
I think oh, sorry.
No, an interesting interface would be, I didn't address it, but the trade secrets issue. I mean, if the companies would then have an interest, the company developing the algorithms would have an interest to reveal more about the algorithm if they want the courts to admit the evidence. And then there would be tension between their desire to protect their trademarks and the desire for admissibility evidence, which could be used to support
I think that's totally right. I think one lever is at admissibility. So if the courts say we're going to condition admissibility on sufficient levels of transparency, that'll have an effect on the prior market, because law enforcement wants, I assume you law enforcement people in the audience, I'd love to hear from you, wants to purchase technologies that are going to be useful in court. And so the courts have a way of affecting the law enforcement market that way, and then the law enforcement market will affect what developers do. Or law enforcement can get ahead of the curve and condition procurement on these, which is basically, I would recommend condition procurement on waiver of trade secret privilege claims and compliance, promises to comply with court-ordered subpoenas. So the Texas law enforcement, I mean, you've got, it's not helpful to law enforcement to have the integrity of their convictions repeatedly litigated up the appellate level. And so for all of these issues, I focus on defense investigations, but I think law enforcement should be on my side for every single one of them. The Texas prosecutors aren't benefiting by the fact that they bought a forensic software system from New Zealand, and the New Zealand company is skirting the court orders. That's no gain to them. Nor does law enforcement benefit when defendants' subpoenas to tech companies are denied. So one thing I'm working on that, I have a white paper I'm putting out for the new administration, advising them to change US DOJ policy on this Stored Communications Act issue. The US attorneys are writing amicus briefs on behalf of tech companies in these cases, supporting their interpretation of the privacy law as a bar on defense subpoenas. But it doesn't do them any good to block defendants or defense counsel from doing their job, which is seeking, investigating evidence of innocence. And there's no legitimate reason for law enforcement to want to block defense counsel from using their normal subpoena power. And actually, a San Diego district attorney kind of bucked the trend last year and filed an amicus brief on behalf of the defense, saying, yeah, it threatens the integrity of our convictions when defendants can't use their normal compulsory process powers. Please interpret this statute to yield to valid subpoenas by defendants. So my hope is more law enforcement will want to do this. I think what I've heard from speaking with legislators, so speaking with this House Judiciary Committee person on trying to encourage that bill to recommend to law enforcement that they condition procurement on waiver, he's told me, but I'd love to hear from the audience and from Carney, your thoughts on this, that law enforcement's concerned that if they gain possession of information about how these software systems work. So Carney, if they have the information to disclose for transparency purposes, if they have the explainability information, first of all, then they have statutory disclosure obligations and Brady disclosure obligations. And so then information about those systems can be contested. They don't have to have disclosure requirements if they don't gain possession. So there's a legitimate version of that concern. We don't want the administrative burden of going to court, maybe. There's maybe a semi-legitimate version of that concern, which is we want to try to limit the contestability of these systems because we've already invested in them and we're locked in, so we don't want them to be challenged. And there's an illegitimate version of that concern, which is we want to avoid disclosing relevant information to defendants.
Okay, this is fascinating. We have a couple of questions from the audience. I will assert at some point the privilege, so to speak, of leading this to ask Rebecca certain questions as well. But please, Professor Eldar Haber from our center. Eldar, the floor is yours.
Hi, thank you, Rebecca. This was a wonderful talk, and it was a fascinating. I think you're doing fascinating work in general. I have some questions which, I mean, I'm baffled by a few of the things that you raised about the Stored Communication Act mainly. And one of them would be first, I'm really intrigued about where you compare the telegraph and I was to the internet. I'm intrigued about knowing whether or not you thought about the comparison between the domestic laws that govern telegraph communication back then, which in the internet, you're talking about the federal laws, which I'm not sure there's a difference to that extent, but there's something there, I would say, to the extent, because I think the first federal law that governed telegraph communication was in 1934. And prior to that, it was only states. So, and you're not, you haven't referred in your talk to anything other than federal legislation when you talked about the internet. So that's my first, it's just a thought experiment of some sort, I would say. And second, when you talk about stored communication, I mean, I think it has a lot of problems. And I think you've noted one of them, and I think it's amazing that you've noticed that. I don't recall anyone that have ever noticed this thing in particular, but I was wondering, do you think, I mean, aside from the first question would be, do you think that whether or not one of the platforms will be classified as either an ECS or an RCS, would that change something in your analysis in the sense that then they will be under the Fourth Amendment? Then what does that change? Because I think that most of these companies now, I think it's hard to make them qualified as either an ECS or an RCS. It's these old, rather vague definitions of something which doesn't exist today, I think, in general. And generally, just on the, you know what, I'll just leave it at that for now.
I'm curious what the third one is, because both of those are like, wow, I wasn't sure, because it's actually my first time in a workshop or sharing a academic space with a Israeli community. I did not realize that there would be somebody with such expertise on the Stored Communications Act. So thank you.
It's not fair. I'm also researching criminal law in the US, so I know a little bit about it.
Wow. Well, I'm really eager to hear about comparative differences and ways that we might learn some things from Israeli law that maybe could improve in the US. So on the state federal part, that's fascinating. I actually didn't even realize there was even in the 1934 Communications Act.
Yes,
the federal
yeah, it was for
it
wiretapping.
affected telegraphs and wiretapping.
Yeah.
Oh, really interesting. So you're absolutely right that the telegraph laws that I'm talking about are state laws, and that the internet law I'm talking about is the federal law. There's other differences as well, besides the scale issue that Carney pointed out. There's also the issue that in this one is actually, like, from a political economy perspective, like a big difference. The statutory silence in the state telegraph laws that courts blew through was silence on law enforcement subpoenas, not silence on defense subpoenas. But we're talking about silence on subpoenas because at that point, there wasn't this idea that the Fourth Amendment applied to law enforcement investigations to contents possessed by private companies, where you've got contents possessed by the US Mail Service. That's a different issue because it's a government possessed communications contents, and people sometimes get those confused. We have no Fourth Amendment protections against law enforcement seizures of, in any event, we have no statutory protections against law enforcement seizures of communications contents in private paper mail services. We do have statutory protections for seizures of private communications content in US Postal Service mail services. So there's a difference between the two. In the telegraph and the internet, we're talking about private companies. But the 1934 Communications Act, I hadn't thought about it in relation to telegraphs. What's really interesting about that law, as I think you might be suggesting, is that when it was enacted, prohibited wiretapping of all kinds. And the US Supreme Court, it had no exception for law enforcement. So unlike these other statutes that have express exceptions for law enforcement, not for defense investigators, it had no exceptions for law enforcement. And instead of courts blowing through the statutory silence and ordering that law enforcement subpoenas can go or defense subpoenas can go in the telegraph company, with the wiretapping, the US Supreme Court said, actually, this creates an evidentiary privilege against wiretapping, and no one, neither law enforcement nor defense counsel nor private civil litigants, can engage in wiretapping. However, and I write about this in the privacy asymmetries piece that looks at the pattern in cross statutes as a whole. However, the 1934 Act said on its face that courts could subpoena service providers for contents of communications that they had otherwise lawfully stored. And so the distinction there is that what I'm talking about with the telegraph laws and the SCA are subpoenas to service providers. They are not eavesdropping or intercepts. There's a different policy concern when somebody engages in wiretapping or break-ins, Computer Fraud and Abuse Act issues, unauthorized access to networks, trespass, cyber trespass. These are different concerns because when you engage in wiretapping, you can never know in advance what exactly you're going to get. And so there's a greater risk of overbroad collection, and we have to do ex post minimization. Whereas when you're doing subpoenas to service providers for previously authorized, previously stored communications contents, you can be very narrow in what gets disclosed. You rely on the service provider to filter, only disclosing relevant information that is actually subject to the subpoena. So there are different policies between these different statutes. The 1934 Act is a really interesting comparison. But I would say that the 1934 Act privileges, under the Nardone cases, the US Supreme Court cases, privileges wiretap materials and I guess intrusions into telegraphs, to wiretap telegraphs, if it privileges them from use in court if there was an unauthorized eavesdropping. But it has an express exception that permits them to be subpoenaed and used in court if it's a court-ordered subpoena to the service provider. And I'm talking about the court-ordered subpoenas to the service providers. In your second point, thank you for saying that about the Stored Communications Act. I need to say, I'm not the first person to identify this disparity in the Stored Communications Act. Christian Janetsky and Mark Zwillinger were attorneys at the US DOJ office, and they actually wrote a short piece that identified this disparity because they had experienced it in their practice and felt it was unfair. They were prosecutors who spoke out against it, and they wrote a piece called something like "Acquittal is just a tweet," or "The Stored Communications Act is not a level playing field," like 10 or 15 years ago. And then it's really dropped off. Eric Luna and Josh Fairfield mentioned this issue briefly in a piece they did called "Digital Innocence." So what I'm adding that's new is, say, bringing this back to the conversation, and also my novel contribution is that we should understand this through the lens of evidence law. We should understand it through the lens of privilege law. So people have identified as unfair that government can get it, but defense counsel can't. Nobody has provided a statutory theory for how to get around this. Instead, litigants and these other two prior groups of scholars who identified it have relied on constitutional rights to try to defeat the statutory barrier. But this goes to what Carney was saying too. Well, what's the burden? You want it on case-by-case basis? How are we going to protect privacy rights? And I think that we shouldn't have to go to the constitutional rights to defeat these barriers, because it's very difficult to satisfy the constitutional burdens. If we instead interpret the statutes to yield, we get the normal subpoena burdens, which honestly are also really difficult to satisfy. In terms of your last question about whether it should be an ECS or an RCS, it's funny that you say that, because one way this conflict with defense counsel might go, I don't know if you're familiar with the case, but the case I mentioned where the San Diego district attorney actually filed an amicus on behalf of the defense, the California Supreme Court last year issued an opinion where they said, we're seriously considering fixing this conflict by saying that Facebook doesn't qualify as an ECS or RCS. So are you working on this issue?
No, I worked about wiretapping. I had a piece on I called it the wiretapping of things. It was published in UC Davis Law Review a year ago. So I worked a little bit about that, but I wanted to push you on that if I can, because there was a case in Arkansas 4 years ago with James Bates as a suspect, where he was a suspect of a murder of one of his friends that was found dead in his hot tub. And then Alexa was playing in the background, and then the police sought to extract the data from Amazon, and Amazon said no. And because they actually, I think they went on the Stored Communication Act, I'm not sure, but what happened there, and this is, as I saw it as a privilege, he had a privilege, because eventually he was acquitted, and he was, because he gave consent, he consented for Amazon to give all his information. So, but he was privileged enough to gain the data. He was the only one who could acquit himself, to say the least, and the government, the state couldn't, they didn't have access. So in that case, the defendant was actually more privileged to some extent than the state. However, I would have to say that I'm not sure how it would have worked out eventually. I would assume that, Amazon refused to hand out the information, but I'm not sure that would hold up in court. So just your thoughts on whether this equation always works for this side, against the defendants or not.
Interesting.
What I want to say is that there's, I think that we're going to see a lot of pushback from companies against the state. Take the Apple FBI, which in other context, but we're going to see a lot of pushback to preserve maybe users' privacy to some extent, and maybe we will see some leverage there of some sort towards the defendants.
Yeah. Well, okay, so great. So let me start with that. Say companies are going to push back to preserve user privacy. And this is something I think pings off of what Carney said before that I didn't respond to. Well, don't we want to incentivize the use of these technologies? Aren't the technologies really good technologies? And that's a legitimate legislative interest. And so, yes, lawmaker, and you, Carney, you mentioned that maybe that's a distinction with telegraphs. It's not a distinction with telegraphs. Lawmakers in the telegraph area had the same amazing, it's like reading, it's like echo, deja vu. You read the legislative records for the Stored Communication Telegraph, that both of them are saying, we can't live modern life without these fast communications, businesses won't survive, personal communications, it's a necessity, it's not even voluntary. The same Carpenter argument, it's not even voluntary to divulge your communications contents to the telegraph companies, because how could you exist without them? And also, if we don't have privacy protections, people won't use them, and that'll stop our economy. So the same kind of policy concerns behind them. But I just do not buy it that we need to suppress defense subpoenas and truth seeking in the courts in order to incentivize use of these technologies. And the reason why that is just not, that is a baseless claim, is that the Stored Communications Act enumerates a plethora of exceptions where companies disclose this data for lots of permissible uses and rely on it for lots of permissible uses. And I'm talking about a very narrow set of circumstances that already has sufficient privacy baked in to the subpoena power. So it does, to look at how privacy invasive these companies are, and then to think with a straight face that they're really trying to protect privacy by quashing criminal defense subpoenas, I just don't buy it. In terms of this, the hot tub case, I need to, you know more about this case than I do. I have a vague memory of it, Alexa, and there was maybe water meter data, and so
yes,
content
there
and
was a
non-content.
water meter, but I'm not sure that the water meter was extracted directly from a company, or I think that they just went to the water meter itself and they extracted data from it. I'm not sure though.
So interesting. So I do think there's all these different types of information that are coming into criminal. So your definition of what is digital forensics today, Fitbit data, your health data on your phone, if we call it as forensics involving digital technologies, it's very broad. So in terms of that, I don't know why law enforcement wouldn't have been able to get the contents of the Alexa communications if they had properly.
It was overbroad. It was overbroad.
Oh, okay. Well, fine. They got to get a warrant under the Fourth Amendment, we think. There's some issues around the third-party doctrine evolving very quickly, but and Warshock, is a Sixth Circuit case that Justice Kennedy has adopted. So presuming you have to comply with the Fourth Amendment, get a warrant. It's not that hard. It's easier to get a warrant than a defense subpoena, for God's sake. The warrant, you get probable cause. You don't have to show the thing is admissible. You just have to show probable cause. So fine. So Amazon's pushing back against an overbroad warrant. Well, they should. They should push back against overbroad warrants. Other issues with overbroad warrants in this space, geolocation warrants, reverse search history warrants. I've seen overbroad warrants routinely to tech companies that say things like, I want all communications contents from this account from inception to the present date. And there's a big struggle that courts are having right now about how to translate the particularity requirement of the Fourth Amendment to the cloud. Well, those things matter a lot, but there's not a categorical bar. If law enforcement abides by whatever we decide is the standard for the warrant, they get the information. Whereas what tech companies are actually saying is we have categorical and absolute immunity to deny defense subpoenas. So the last thing you brought up, the Apple case. So I see the Bernardino case as much more similar to the wiretapping situation. Well, there's a couple different issues here. There's a whole separate issue about when law enforcement can.
I agree. The Apple case is different. The Apple case is different from so many respects, and I think it might be a First Amendment issue. It could be a lot of different things that they argue there. Let's not. I want to open the floor for others, and unfortunately I have to leave. I'm sorry. Thank you very much.
I'm so thrilled to learn about your work, and I'm going to check the wiretapping of things in Davis. Thank you for that. Nice to meet you.
Likewise.
Thank you very much, Eldar. I see some other questions in the chat, so please, people, if you have further questions to either Rebecca or Carney, please either raise your hand or write them down in chat, and I will relate to them. But I want to perhaps introduce some comments or pushback, so to speak, on the following issue. So I think one thing that we should do perhaps is to distinguish the industry here and to try to separate two categories. One is the service providers. So that is the Amazons or the Googles, the Gmails, etc. And one is the software that actually is in the business of extracting data, right? So they're both players here, but I think it plays out differently when you talk to when you direct the regulation towards one or the other because of the nature of the ecosystem. So with that in mind, let's talk about IP and trade secrets. And here we have, I think, two observations. I'm sure you've some of it is mentioned in the paper, but and I'm sure you've thought about it. Broadly speaking, IP generating access to the actual software that is used for either the Celebrites of the world, that is software that is used to extract information, or the Googles of the world, which is where the data relies, and you want to make sure that nobody implanted anything and it is in fact authentic and true. So when you talk about IP and defense and legitimate interest of defense, well, they may want both. And you've addressed primarily the IP rights of the Celebrites, but as a matter of rationale, then our intuition, I think, might differ slightly when it comes to the IP rights of Facebook's, Amazon, if they have to disclose how they maintain their data and whether something was implanted or not implanted and it's authentic or not authentic, which is up for grabs if you really care about the power of defense to conduct investigations. This is point number one. Point number two is about leveling the playing field. So one of your major points was let's level the playing field in the sense that the prosecution has this huge advantage, and not only because of fairness, but because of due process. This is not a good idea. And in fact, it violates rights disproportionately, etc. But then to the extent we are within the due process segment, wouldn't you say that there would be great disparities between the haves and the have-nots? Because those that can actually analyze sophisticated IP, sophisticated the software of the Celebrites, even if we just take the Celebrites, even if we say, well, there is a distinction between the Celebrites and the Googles, you'd have to have lots of resources. And I'm not sure that the inmate in Texas alone would be able to do anything meaningful with that unless you harness the market. So either you have NGOs who do this for NGOs purposes, and then the state has to fund them, or they have to have some donations or something, or there is an underlying current somewhere for business to say, I'm going to provide software that would audit somehow the minutiae, the operations of that, and then you did have a secondary business, and then you have to think of the ecosystem and accessibility issues, and it may tie back to the issues of you have the right to a counsel. If you cannot afford one will be provided for you. Well, what does counsel mean? Is it actually just the person, the counsel, or is it effective counsel, including funding for all that? So that raises a whole lot of other issues, I think, that you bring to us. We cannot ignore them in the US, but also in other systems where the issue is modeled or regulated slightly differently. So that's with respect to the IP. Now, with respect to the privacy, so you very forcefully argue that there could be a third-party privacy issue there. Why? Because once we delve in, the nature of data now in the modern world is that it is not necessarily individualized. So my data in my emails or in the Alexa may also capture inadvertently, and in fact, we should anticipate that it would capture data of third parties because maybe another person was there, or maybe it's the email with a third party, and maybe there are data trails of third parties there, and their privacy issues may be involved. Now, if this is indeed the case, if the ecosystem, so it's distinct from telegraph in the sense that telegraph is one-to-one. And I think that's the major difference, not because people, and I totally agree with you, that in the old days when you read about the telegraph, it was a huge revolution. People talk about the before and the after, and wow, we're in a different world. It's instantaneous and you can know, and without it, you cannot survive, etc. What is unique and distinct is the telegraph is point to point. Whereas this new ecosystem enmeshes interoperability with many third parties, and the data can be traced, and privacy becomes much more complex. So you say, well, a third person can quash. The third party can be given an opportunity to quash. But there are externalities here, because then you have to seek out the third parties in the email or in the Alexa conversation, et cetera, et cetera. They may not have resources, but that's a point I've already made in terms of imbalances of power. But they also may have legitimate privacy concerns not even to be identified. So the notion is you identify them, you give them standing, and then but they may say, hey, look, just for me to be identified here, I've already lost the privacy concern, because I don't want people to know that I'm the secret lover. And Alexa captured me because that's the nature of the ecosystem that I'm being captured. And sure, I can now stand and say I'm actually the secret lover. But so it's actually a little bit more complex when you talk about third parties. Whether they gave consent, is consent really the meaningful standard here? At least in Europe, it's not necessarily. So it gets messier. And the last point I want to make is it relates to the transnational dimension here. And here you also point to the relative advantage of the executives. The executives are just better at communicating with other executives, and they do it through various devices. You identified some of them with respect to the criminal procedure. When it comes to national security, it gets even broader than that. And some of it then filters back to the criminal system, because there are ways to get information from the NSAs of the world to the FBIs of the world in a certain manner. And here, then the question becomes, again, the question of the ecosystem, in addition to what you said. So I totally subscribe to what you say, and I agree, and it's wonderful. But I want to push back a little bit, in the sense that here, two things have to be said. One is, wouldn't you say that the first thing to consider would be actually to contact the Cellebrites of the world and ask them whether they're willing to sell some of the information? What do I mean by that? So the amazing work of the council you talked about, he went to the spoofing software and just said, well, let's talk. Now, they didn't resist the subpoena, right? They didn't say, oh, I couldn't. They said, fine, I'll play, I'll deal, fine. In fact, I might get publicity out of it, because people will know my service, and who knows?
Everybody here now can go spoof.
Everybody, now we can purchase their spoofing services, and
spoof card.
Who knows? Something can come out of it. Something can come out of it. But when now I have to deal with New Zealand and this and that and the other, maybe I can just go there as a defense and ask them, are you willing to sell some of your services if it's the spoofing, the Cellebrites? If it's the Googles, it may be more difficult. But so that's point number one. Point number two here is that especially when it comes to transnational issues. You mentioned in passing the notion of trafficking and drugs and all the transnational crime as such. But there are also crimes against corporations. I mean, there are also criminal proceedings against corporations. And here, my point is that what counts as criminal and what counts as civil becomes murkier, because in some jurisdictions, it's purely civil. In some jurisdictions, it becomes administrative, because the state can remove licenses and then the state becomes a player. The state can sue in civil courts, as in the US, the Attorney General can sue. It's a civil case, but it's actually a public law civil, even though it's civil, it's a public law interest that the states represent. And sometimes it's criminal against corporations. If you talk about the EU, they can fine the Googles and use their regulatory power in regulatory proceedings, a lot of money. And if then they say, okay, we want access to this information, then the defense says, well, I want access to that information. It's more complicated than just a civil criminal when you talk about the transnational, at least when you talk about the transnational. So these are the 3 points. There are more comments in the chats, but I want to give you the opportunity, of course, to see whether you can make anything out of those comments at all.
Oh, they're wonderful comments. They're so helpful. I just took 2 pages of notes and I'm really excited about all of them. So they're really helpful pushbacks, and I welcome lots of pushbacks. It helps me think through the issues better. And just on that, and because I want to hear from other people too, but in terms of the transnational and corporate crimes, criminal proceedings, or civil, administrative, whatever they are against corporations, I really would love to find more examples of possible criminal defense investigations where U.S. Defense Counsel would be seeking evidence from a non-party stored abroad. And so if you have, they're there, but it's not a white collar criminal defense is not an area that I know a lot about. Corporate defense, same. I would love to collect more examples if anybody knows fact patterns or cases where that would have come up. So let me go in reverse order because then I'll have it freshest in my mind. But you said also on the transnational part, you said, well, what about, Spoof Card was willing to play. They complied with the subpoena. They didn't try to resist it. In fact, they might have complied with an invalid subpoena, to tell you the truth, because they disclosed contents and never pushed it back on the SCA. So there may be a little bit, they didn't actually know what they were doing there. But although I think it was valid, I think they should have. Cellebrite and Graykey, who build these digital forensic device extraction systems, have refused to sell to defense counsel. So they are out there on record saying, we won't play. You have to, state that you are a law enforcement officer to participate in trainings or to buy one of these systems. I think that's absurd, but their rationales are somewhat different than merely IP. So this is just to distinguish. There are lots of reasons that you would want to quash subpoenas. Privacy is one, intellectual property is another, but a third is security. Yeah. And concerns about circumvention. And what are the consequences of a leak? Is it just my IP is destroyed, or the effectiveness of my law enforcement investigative tool is destroyed because now it can be circumvented by future criminals? I don't know, because there's so much secrecy and it's not an area that I focused on, what kinds of anti-circumvention assertions are valid and which ones aren't. There's a risk with assertions of secrecy around security, national security, law enforcement, that of course, there's a risk with any assertion of secrecy that they can be abused. And so how do we know when there's an overbroad claim, when there's a false claim, whether it's a valid claim, because there's a very real reason there to protect secrecy. I don't know, you must know the leading case in the US Supreme Court on the state secrets privilege, US versus Reynolds, that established that the US government can assert national security secrets to withhold information from the courts. And if there's a senior official who swears to it, plus sufficient circumstances supporting the claim, the court doesn't even do in-camera review. So we withhold that information from our judges even when the security risks are sufficiently high. So that's just a separate kind of a concern that I'm not addressing when I'm addressing IP, that I'm not addressing when I'm addressing privacy. I believe sometimes people try to use IP because they're actually concerned about anti-circumvention. And I'll tell you when that has happened. That's happened with something called the Child Protective System software system in the US, which is a system that's designed to basically modify peer-to-peer software systems to be able to get downloads of an entire file from one source when you're looking for contraband files like child sexual abuse material files. So you don't want to get bits and pieces from lots of sources. You want to get the whole file from the source that you're investigating. And this software system allows you to do that. But there are some issues about warrants and when law enforcement could or couldn't use it. And so some ex-law enforcement personnel created effectively an NGO that does this. and then provide, as a private non-governmental actor, provides a tip to law enforcement to get the warrant and then go back and do it again. And so there have been issues with that around that organization trying to assert that they are both not a government actor for purposes of the Fourth Amendment, but they have law enforcement anti-circumvention secrecy interests. And it's like, you can't have it both ways. And so they sometimes turn to IP to try to walk that line. So so I agree that people shove the security concern in the IP bucket, but it's not, it shouldn't be there. If you have an IP claim, make the IP. You have a security claim, you know, maybe we need to change the security protection so that non-governmental actors can validate, but make it real what you're actually arguing. Yeah. I love your point about telegraphs one-to-one and the internet, and this is kind of also what Carney was saying, the stakes, the scale. You know, this is a particular instance where stakes and scale are so much higher with digital technologies, where, as Professor Reichman pointed out, you have the kind of common good aspect of privacy, where one person's disclosure might implicate privacy interests of another. And I just, you know, if we don't protect that third party, if we don't protect that anonymous lover in a non-digital space in our criminal procedure rules, I don't think they should gain new protections just because the exposure is digital rather than the neighbor viewing them in the house or the love letter they sent to the, you know, whatever, you know, you know, protecting your anonymity, I don't think is a very persuasive
point is that
pushback.
they wouldn't necessarily be captured in the non-digital world, because if the neighbor isn't watching, then fine. But here, it's stored forever. It's kept. It's stored forever. It's just, you know.
That's that's the really sophisticated version of the counter argument that I'm just going to say I don't have a way to rebut. And that's absolutely right, that there's two things going on here. You can either approach these problems and say, we want to maintain the status quo of the kind of information that was or wasn't available to law enforcement with prior technologies. And if it didn't exist before, we don't want it to be accessible now. That's the position you're just arguing. I would like, and what that does, that position rhetorically, is it puts people like me on the side of arguing for change, and it claims the authority of the status quo on the side of secrecy. So one of the things I'm trying to do with my work overall is flip that. I want to be on the side of the status quo. I want the other people on the side of arguing for change. And so I want to say, no, the status quo we should be trying to protect is not the exact quantum of information that was or wasn't available with prior technologies. Rather, the status quo we should protect are the legal standards that we've written in. So if the technology, if the information didn't exist before and would have been relevant and material to a criminal investigation and the truth seeking of the courts, it's too bad it didn't exist before. Yeah. So the standards I want to keep the same are, when the court says it's relevant and material and it's exculpatory and it's admissible, that is what we should keep the same, not say we're going to have new secrecy protections for information just because it happens to have been revealed through a new technology. But you and I could go back and forth forever on that, and hopefully you won't completely destroy my position, but that's a really challenging counter argument. I don't have a way around it. I have so many more things that I wrote down from for third party quash, general, Google, Facebook, Celebrate. Could my argument about the security of needing to interrogate the security of software for Celebrate, where the IP claim is really about a very particular market, where I think I'm right to say, from market incentives, if we require disclosure, companies that exclusively sell to law enforcement will still exist and they'll just comply with disclosure. But companies like Facebook or Google, it's a really different thing to ask them to reveal their trade secrets because it would threaten such a broad market. And I agree. So I'm worried about that. I still think attorney's eyes only protective orders, which has many conditions as you want to put in, should suffice. They suffice for civil litigation. They suffice for trade secret misappropriation suits. They suffice in business negotiations. That's what companies rely on in their contracts. So why isn't it good enough for criminal defendants? You also have the haves, have not. So I have a response to that one, but I feel like I'm blabbing on and on and on. So
no, that's great. I just wanna very briefly draw some of the others. So Dalit Kendro from our legal clinics, who actually runs our law and technology legal clinic in Haifa, and also has a PhD in law and technology, was wondering whether you would like to comment on the emerging of deepfake and AI and how that may impact your three-pronged argument with respect to access of defense to data. And I can jump into that and saying, do you want to automate that as well? So eventually, I guess there will be a market for defense software. And then, you know, how would that look?
I mean, what a wonderful point. And I think, and I just saw this chat, it says that you're working on this area. So are you working on AI and deepfakes in criminal procedure specifically, or what is it your focus?
More in the political discourse, but I'm sorry, I have noisier around, so that's why I wrote it and didn't ask you. No, I'm just research it from the point of how to influence people and change their political views, but also writing a little bit of how it will affect the law and everything like that.
Wonderful. I mean, such an important and fascinating area.
And thank you very much for your wonderful talk. It was wonderful. Thank you. And thank you, Connie, as well.
Yeah. Thank you to Carney as well. Yeah. Thank you to all of you for coming. It's been really fun. So yeah, I think also as Professor Erkin's saying, yes, I'm interested in why we are developing AI systems for law enforcement use, but not for defense use. And so this also gets back to the haves, have-nots issue, but there's a well-known market failure in forensic markets where law enforcement has the money. And so the systems are built for and are designed for law enforcement uses. Now, those are important uses, but they're not there. But there's other important uses in the criminal system that aren't being incentivized in the market. And so one way to try to fix that is, for instance, I showed you this bill that the Congress is about to enact to create a center for digital excellence and provide all this federal funding to law enforcement. Why don't we provide some federal funding for defendants? So for AI, yes, these issues are going to be more and more important for AI, as you're saying. An example is, you need access to data to train an AI system. You need access to the AI system that's trained to use it. And then you need access, at least in the forensic context, often pattern matching, to a database to run the system against. So take face recognition. You're gonna say you have a face recognition database trained on Facebook's, it's Clearview AI, whatever it is, and we're gonna sell it exclusively to law enforcement. So what if all of a sudden we also sell it to defense counsel? Where are they gonna run it against? Are they running it against DMV photo databases? Well, are those exclusively possessed by the government? Are we going to let defense counsel run the system against government databases? Are we going to let them run it against private databases? And so we've seen it was an interesting thing, I think, that's happening with AI, when we were only talking about government possessed DNA databases. This was a big problem. Are they part of Brady? How to defend it? We had to enact in the US separate statutes in order to give post-conviction defendants rights to run DNA evidence against state-controlled databases to prove their innocence in the exculpatory evidence innocence movement. So there's a question, who's going to get to use them, to build them? How are they going to decide who's going to get to deploy them? Now that many of our databases are actually becoming privatized. So it used to be the government possesses all the face matching databases. Now the private sector does. The government possessed all the fingerprint databases, now the government, the DNA databases, now the private sector. So many of the debates around who could access these databases that used to be in the Brady due process context, I think are going to have to go into this other private markets statutory context that I'm talking about. So one answer to your question is yes, I think defendants, I would argue, should be able to have equitable, bounded, regulated, properly constrained, but just access to AI systems, that those systems should be designed to serve their interests as well. So I recommend a wonderful article by somebody, Andrew Ferguson, called, well, I forget what it's called right now, actually. But Andrew Ferguson, it's an article in UCLA Law Review, pointing out that prosecutors are using big data AI tools to allocate prosecutorial resources, and decide to run on databases and decide who to prosecute. Those systems are helping prosecutors parse and make use of vast quantities of data, but they're not designed to flag exculpatory information in the databases, even though it's actually a prosecutorial task to identify and disclose exculpatory information in their possession. So this is a part of the market failure again. How do we define what tools get used, what questions get asked, who they're designed for, what are the goals? So I think those are issues with AI that are going to be very relevant in what I'm looking at. I don't think deep fakes are all that relevant. I don't, you know, this is maybe for evidence in criminal procedure. I think they're extraordinarily relevant for what you're doing in terms of political misinformation and democracy and what kind of debates we have in the political, so how are we going to have extraordinarily important there. I struggle to find a reason why our existing evidence authentication rules are insufficient to handle deepfake, the threat of deepfake evidence in courts. So that's maybe another conversation, but that's how I've looked a little into it, maybe not enough, so I could easily be wrong here. But I tend to think people have been submitting fraudulent information to the courts since they wrote words on paper. And we have these authentication rules designed to address that. And what's different about deepfakes is, you know, we look at circumstantial evidence, indicia of fraud. Why can't we look at those for one thing that would be interesting that I don't think has happened, but could be really cool to get off just the defense side. I do think there's a lot of fraudulent evidence submitted to the courts. When I was clerking, we saw some fraudulent emails submitted to the courts in the Southern District of New York. And so I wonder, now there's all these AI systems being trained to detect fraud in different contexts. Wouldn't it be interesting and maybe helpful to have a judiciary AI fraud detection system where we just, you know, when documents are filed digitally with the courts, it just pings against this and maybe flags some indicia of like, this is a little suspicious. This email has some metadata that was manipulated that you might not have caught, or I don't know, but maybe that would be a good thing.
So I want to pick up on that. We're drawing near to conclusion, but I want to pick up exactly on that because that's how we talked about the prosecution. We talked about the defense. We talked a little bit about the industry as well.
Yeah.
We didn't talk about the state's other capacities. So I come from public law and regulation, and so I see the state too much, almost everywhere. But you know, the state has a role both as an actor, as a player, and as a regulator that hasn't been really addressed. One clear elephant in the room is the by design movement. And perhaps what you're saying is that we should also think about due process by design, not only just privacy, not only privacy by design. So perhaps the new article coming up from the Cyber Center in Haifa and Rebecca Wexler could be due process by design that says we have to regulate the Celebrites or the other software that actually assists judges and assists the courts, all the administration, to include due process by design, so that when things we care about are relevant, the technology is there to assist us. That's one role of a potential regulator that looks at that. The other is that the state is an actor, and this is exactly what you're saying. The state can induce the market to say, hey, Celebrites out there, or hey, Google's out there, you're in the data business, but tell us if we're making a mistake, because you want to be on the good side, on the good guy's side, right? So let us know if there was deep fake or something was planted. You think that something was planted on a phone, because we know, and I don't want to say that currently police is implicated in those kind of things, but we know that in some parts of the world, it has been known that the police force used to implant, marijuana or some other drugs in people's cars, and then go prove that that it wasn't there before, because the police person said, I found it. And then, even though the onus technically is on the police to show beyond reasonable doubt, but you couldn't realistically show otherwise. And it was the same with DNA, as you've noted. And now we tend to kind of be a little bit more suspicious with DNA to an extent when it wasn't stored. But with digital, we don't really know. I mean, we're still lacking some knowledge. What was planted, maybe it was manipulated somehow. So the state may have a role to induce the market to find some market solutions. So that may also be part of what we are hearing from you here, that connects the 3 points together of IP. You flip the IP, you say the IP, but now the IP are on the right they're on the right side. Mm-hmm. And the privacy is on the right side because we built it into the design, and then the transnational as well, because we care about a transnational standard for those kind of things.
What a wonderful way to sum up, give a meta spin on this conversation, meta commentary on this whole conversation.
So we're drawing to an end. We're almost at 8 o'clock in our time, and that's late. Wow. People have to go.
I'm amazed I really want to thank you. Thank you so much for coming. This was really fun. I really enjoyed. What wonderful, insightful comments and questions and thoughts, and wow.
And when the corona is over, we're going to have you in person.
I would love that.
Karni as well. We're going to have you in Haifa. We're going to celebrate what Haifa has to offer. It's going to be fun.
I can't wait. That sounds really wonderful. And excellent. Everybody stay safe. And yeah, and I'm so excited to learn about all of your work. And Karni, so really excited to meet you.
You too.
So hopefully we'll continue to stay in touch, and Dalit as well.
Thank you very much.
Thank you very much.
Thank you all.
We're concluding here, and I wanna just mention for the few people who are still with us, we have a conference next week. We have next Wednesday and Thursday. We have a week on the AI, on the Corona issue, AI in the Corona, and hacking to steal the virus of the Corona, cyber-related issues, which are quite fascinating. So that's going to be held in Haifa and in Jerusalem together, of course, via Zoom. And interested people we can send you the invites. You can attend via Zoom. Thank you, Rebecca, and good morning to you. Good evening to everybody else.
Thank you for coming and staying. What a pleasure.
Thank you.
Bye-bye.